Hey everybody, we got some huge news that I want to bring to you that happened yesterday that has changed things nationwide, at least for now. Yesterday, Judge Thomas S. Cleath, a federal district court judge in the Northern District of West Virginia, issued a decision striking down the federal prohibition against 18 to 20-year-olds purchasing handguns from FFLs. Yeah, like I said, this is a huge decision. The plaintiffs in the case are Stephen Robert Brown, Benjamin Weakley, the Second Amendment Foundation, and the West Virginia Citizens Defense League. Brown and Weakley each tried to buy a handgun from an FFL, but were refused because they were under 21 years of age. Guys, this is huge. Before I get into this decision, I want to thank the sponsor of the video, and that's the Sonoran Desert Institute. I know a lot of you out there, just like myself, you like to repair or modify or upgrade your own guns. And if you're looking for a way to take your hobby to the next level and make money as a profession, then the Sonoran Desert Institute can help. The online programs at SDI cover armors, courses, woodworking and finishing, ballistics, gunsmithing, shooting sports management, and much more. Plus, the tools and materials that you need are shipped directly to your door for hands-on practice. It's never been a better time to get an education you can actually use on the job. So, what are you waiting for? Visit sdi.edu/GNG. Link is down below if you want to learn more. I appreciate you, SDI, for being a sponsor. Thank you so much. Guys, my name is Jared. This is Guns and Gadgets. On this channel, I bring you all the news in the Second Amendment, good, bad, ugly, or indifferent, no matter where it happens in the country, from legislation to litigation and everything in between. And this piece of litigation has destroyed a piece of legislation. Let's get into it. Here is part of what this judge said. He said, this case requires the court to assess the protected right of the people under the Second Amendment of the Constitution to keep and bear arms. Plaintiffs Robert Brown and Benjamin Weakley, individuals, are law-abiding, responsible adult citizens who wish to purchase handguns. Brown and Weakley are citizens of West Virginia and the United States of America and are between the ages of 18 and 21. Brown and Weakley, as law-abiding, responsible adult citizens, would purchase handguns and handgun ammunition from federal firearms licensees, but for the right prescribed by 18 U.S.C. 922b1 and c1, which says they can't because of their age. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. To demonstrate the regulation of that conduct is within the bounds of the Second Amendment, the government must demonstrate that the regulation is consistent with the nation's historic tradition of firearm regulation. Only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside of the Second Amendment's unqualified command. The test that we set forth in Heller and apply today, thanks to Bruin, requires courts to assess whether modern firearm regulations are consistent with the Second Amendment's text and historical understanding. The core issue the court must answer under Bruin remains whether our nation's history and tradition contains analogous restrictions on the ability of 18 to 20-year-olds to purchase firearms. The defendants, the ATF, have not presented any evidence of age-based restrictions on the purchase or sale of firearms from them before or at the founding or during the early republic. The defendants, likewise, have failed to offer evidence of similar regulation between then and 1791 or in a relevant time frame thereafter. For that reason alone, the defendants have not met the burden imposed by Bruin. Finally, the lack of analogous evidence of founding-era regulations demonstrates that the statutes and regulations at issue are inconsistent with the Second Amendment. Since time immemorial, teenagers have been, well, teenagers. The general societal problem of teenage impetuousness and rashness far precedes the founding era. Yet, that fact notwithstanding, the government has not demonstrated that the founders dealt with this problem in a distinctly similar way to the statutes and regulations at issue. The lack of analogous regulations permits a finding that the founders considered age-based regulations on the purchase of firearms to circumscribe the right to keep and bear arms confirmed by the Second Amendment. In summary, because plaintiff's conduct, the purchase of handguns, falls within the Second Amendment's unqualified command, and the challenged statutes and regulations are not consistent with the nation's historic tradition of firearm regulation, the court finds 18 U.S.C. 922 B1 and C1 facially unconstitutional as applied to the plaintiffs. Plaintiffs, having demonstrated there is no genuine dispute of material fact and that they are entitled to judgment as a matter of law, their motion for summary judgment is granted. For the same reasons, defendant's motion to dismiss is denied. The conclusion: for the reasons discussed, the court denies defendant's motion to dismiss and grants the plaintiff's motion for summary judgment. Defendants are enjoined. That means the ATF cannot enforce. The defendants are enjoined from enforcing 18 U.S.C. 922 B1 and C1 against plaintiffs and otherwise qualified 18 to 20-year-olds. It is so ordered, December 1st, 2023, Judge Thomas S. Cleef. So I know right now everybody's saying, well, what about me in San Jose, California? The answer right now is yes. According to this judge, the ATF cannot enforce that, which means that right now, 18 to 20-year-olds should be able to purchase a handgun from FFLs. However, the NICS system is set up to automatically deny somebody if they're under age of 21. So we'll see what happens. I assume there will be an immediate appeal because the anti-gunners, especially the government, you've seen it here. I've just documented the thing, everything since Bruin. They want to fight and fight and fight or create new ways to do the same thing they were, just word it differently. This will be appealed, but as of right now, the federal government is enjoined from enforcing that restriction against 18 through 20-year-olds. A little more America today, a little more individual liberty. Thanks to the Second Amendment Foundation and the West Virginia Citizens Defense League. Guys and gals, I always say support those who support you. I'll have links down below in the video. Every video I have, there's a link to join and support Second Amendment Foundation. Why haven't you done it? I don't know, but now's your chance. Guys and gals, thank you for your time. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. Why? Because that is consistent with the text, history, and tradition of firearm regulation here in America. And I'll see you on the next one. Take care.